All right, well, hey, let's go ahead and get this party started. First and foremost, happy Valentine's Day to everybody participating. What a wonderful holiday, right? Or maybe it's one that you think the florists and card companies of the world created. Whatever you believe, happy Valentine's Day nonetheless. Y'all may or may not know me, but my name's Clint Brown. I'm a shareholder with the law firm Roberts Markel Weinberg Butler Haley. I actually lead our Property Owners Association division across the state of Texas. I'm also board certified in Property Owners Association law and residential real estate. I'm also pleased, very pleased to have with me today one of our paralegals, Miss Mary Shiloh. Mary, for those of you that were not part of our 101 series last week, Mary is actually one of the few, if not only, bankruptcy board certified paralegals that works for a creditor's law firm. So we're very fortunate to have Mary on our team. And Miss Shiloh and I are going to be talking about Bankruptcy 201. So this follows in our 101, 201 series. It goes into a little bit more depth, a little bit more of the nuts and bolts of bankruptcy and what Mary and or myself have to deal with when we're talking about HOA or condo debt and trying to get that collected when there is an active bankruptcy. All right, I'm an attorney. Got to do that lawyer disclaimer. The information presented today is based on the law as it exists today, February 14th, 2023, and it's being presented for educational purposes and does not constitute legal advice. Mary and I get it. There may be some quote unquote hypotheticals asked throughout the course of this discussion. That is okay. But just remember, it is not legal advice. And if it is something that's important, make sure you reach out to your counsel so that he, she, or they can give you proper legal advice. So we'll kind of be monitoring Q&A as we go through this presentation, but Mary and I are going to try to carve out 10 to 15 minutes, maybe a little bit more time there at the end to answer any questions that pop up. So with that, let's go ahead and get started. So our overview, we're going to give an automatic stay refresher because, again, it's been a week since our 101 presentation, and then maybe somebody is participating today that did not participate last week. So we'll do that refresher, and then we're going to go into kind of COVID-related issues, things that we've been having to deal with in 2020, 2021, 2022, and maybe a little bit into this year as well. We'll talk a little bit about what is the HOA reserve. It's not the reserve that you think. It's actually a bankruptcy reserve, and Mary's going to go into details on that. We'll talk about dismissal moving forward when there's been a dismissal. And again, dismissal, dissed, kicked out. What does that mean and how we can properly move forward? And then we'll get into discharge. So kind of the completing it properly and what we've got to think about when there's been a discharge. And then we'll finish it all up with a nice kind of roundup to talk about the summary. So with that, let's go ahead and get going. Miss Shiloh, give us a little refresher on the automatic stay.
Okay, so the automatic stay is the provision in the bankruptcy code that protects the debtor or your homeowner, the person that owes the money that had to file bankruptcy. So generally speaking, as soon as the bankruptcy is filed, it stops, absolutely stops foreclosure posting, foreclosure sale, collections in any form, and demand letter issuance. Now, if you'll recall from last week, it's 2 words specified in the statute. It stops any act. So any act to collect, foreclose, pursue, charge back legal fees, charge back admin fees, late charges, any type of additional measure that's added to a collection, specifically of a debt that was owed prior to the petition date or the date that they filed the bankruptcy, but it can also include any provision toward post-petition debt collection as the bankruptcy is ongoing. So if you see on the slide, what if the owner's tenant files bankruptcy? This has been a recurring issue that we've had with several quirky type properties where there is an owner who owns the property but rents it out, and there's some issue either between the owner and the tenant, or the tenant trying to possibly purchase the property or otherwise need to impose an automatic stay through a bankruptcy filing to protect the property from a foreclosure posting, not always ours, not always the HOA, sometimes the mortgage, but even if the owner's tenant files bankruptcy, yes, there is still a stay under 11 USC section 362. And a little further on, Clint's going to go into the difference between the property, which is a estate, bankruptcy estate property, and the person. We'll go a little bit more in depth, but just keep in mind that it's a stay against any act to collect a debt.
And when you kind of step back and look at the forest through the trees, this makes sense because a tenant is filing bankruptcy and it's their residence. So even though they may not be an owner of the property, it is their residence. They need to live day to day to make it through the bankruptcy. If it's a Chapter 13, they've got to keep a good job under them. They've got to do everything they need to do. So bankruptcy courts recognize that and tend to offer protections to that debtor, even though they're a tenant and they're not the owner of the property. It's considered what's called an executory contract in bankruptcy law. And it's not as strong of protections, but it's still going to be difficult to get the stay lifted when we're dealing with a tenant filing for bankruptcy protection. So it is a tricky one. And we'll go into some examples later on in today's presentation. Okay, so automatic stay, it stays in effect. It's active until some sort of bankruptcy court order alters the automatic stay. So what are ways where we can get this stay altered or removed in completion? So an order denying or granting relief from the automatic stay. So we could file what's called a motion to lift the automatic stay, and if a court ultimately grants that, that would lift the automatic stay as it relates to the capital P property. And again, I say capital P property because there's a really important distinction we need to make later on. An order of dismissal. So here's Mary's kind of way to make you remember getting dissed.
Yes.
Yeah. So dismiss. So getting dissed, getting kicked out. So that's bad for the debtor, good for the creditor. A discharge of the debtor, honorable discharge. Think that. So the debtor, that's good for the debtor and not necessarily great for the association. And then finally, what is a very tricky one, and I'll let Mary go into this in a little greater detail, is when an owner files a Chapter 13 plan, and in the plan it says that I'm gonna surrender the home. I'm surrendering it. I don't want it anymore. I'm surrendering it. And then the plan gets confirmed. So Mary, when that happens, does that mean everything's great and now we have the property back? And oh, what wonderful news. What typically happens on a surrender?
Oh, if only that were true. So what actually happens on a surrender, and you rarely, if ever, see this happen, although Clint had one recently, but you rarely see this happen where there's no mortgage, okay? Where the property is owned outright by the homeowner, you're rarely going to see the homeowner surrender their interest in the property. It can happen, but it's very rare. So what happens to the property? So the debtor finally realizes, hey, I'm living in a house I can't afford. And so a lot of times I try to describe it as putting their car in reverse, backing out of the driveway, stopping at the mailbox, taking the keys to the property, sticking it in the mailbox, and backing out the rest of the way of the driveway and exiting, leaving, vacating, abandoning. Surrender is the actual contractual term inside the provision of the Chapter 13 plan. Now, a lot of times the Chapter 13 will convert to a Chapter 7. We call those a Chapter 20, of course, to where the homeowner is saying, I can't pay these, I can't have the trustee taking my whole paycheck every payday. I can't pay these secured debts. So I'm going to convert to a Chapter 7, surrender the home, and then a different trustee comes in, a Chapter 7 trustee. And that trustee has to evaluate the property and see if it's worth trying to liquidate, sell it to pay the mortgage, HOA, taxes, any home equity or second mortgage that may exist, or reverse mortgage. Hope not. But, and then if that Chapter 7 trustee determines that no, the bankruptcy estate cannot administer this property, liquidate any funds from it, then that trustee abandons the property. So it essentially goes back to the debtor, basically. But if the debtor has already filed a declaration to surrender the property, then the property is essentially under the mortgage. Okay? So you can't take a property like this that's surrendered, then abandoned by a Chapter 7 trustee, vacated by the tenant, and just have the association start to own it. I wish it were that simple. It's not. There's a whole process about the mortgage, and is it going to be paid, or is the mortgage company going to foreclose it under their power of sale?
Right. And so what makes a surrender distinct from a normal kind of foreclosure situation is that the debtor is still in an active bankruptcy, but they have surrendered their interest in the property. And what really frustrates bankruptcy judges and our law firm and our clients is that they surrender it, but guess what? They continue to live on property day after day after day. And so what an association has to look at and think about is, do I want to spend money to initiate a foreclosure proceeding, knowing that there's a mortgage on the property, knowing that they can foreclose on it because they see the surrender as well? Maybe they do, maybe they don't. So again, it's something an association has to look at. But when the property has been surrendered, technically there is no stay as it relates to the capital P property. So can the association initiate foreclosure? Yes, against the property only. But should it? And that's where kind of you've got to get with your counsel and make a decision whether or not it's worth spending the money, knowing that you may never see that money again if the mortgage company beats us to the foreclosure doorsteps. All right, Miss Shiloh, we discussed this a little bit last week, but why don't you talk us through, this serial filing issue and case law on it?
So truly, believe it or not, it's not how many times they can file. Been able to go into the bankruptcy court and make that issue and get an order granted in favor of an association. We have done that before, but it's not statutorily how many times can they file. Now, in 2005, there was a considerable reform done to the bankruptcy law, and we call it BAP-CPA. Some people call it BAP-CPA. Kind of sounds like a mouthwash or something, but it's the Bankruptcy Abuse Prevention and Consumer Protection Act. It was passed in 2005, and it completely changed the way people can file bankruptcy. What that means is that it was no longer easy for somebody to just rack up a bunch of credit card debt and charge up a bunch of, store accounts and then file a Chapter 7. No, it changed specifically to where if you own a home and it is worth more than a certain amount of dollars, and you have this in assets, this in liabilities, and this in income, you have to file a Chapter 13 bankruptcy, and you have to pay your creditors. That was the big reform. So, as part of the reform, there was specific additional provision added to 11 USC section 362(3) and 4. So 362(c)(3) and 362(c)(4. And what that provides is that, and you may remember from last time, if not, I implore everyone to go back and watch it. Kyle has it uploaded now to the RMWBH YouTube page, the Bankruptcy 101, where we explain that if they file a bankruptcy and they're dismissed from that bankruptcy, dismissed, okay, and they file another bankruptcy within 12 months or 1 year from the dismissal of that other bankruptcy, then they have to file a special motion and they have to obtain an order granting it within 30 days of the new current bankruptcy. So that's the provision to 11 USC 362(c)(3. Okay. Then if they're in that second bankruptcy, right, and they're hobbling along just long enough to get the HOA foreclosure sale canceled after the 5th time, and the HOA has a judgment and everything, and we're sitting on lots of fees, and your board is going bonkers trying to figure out how can we break through this. So then if they're dismissed out of that second bankruptcy, okay, and then we go through the process again, or their mortgage comes in and they post a foreclosure sale and they file a third bankruptcy, where they file a bankruptcy within 12 months or 1 year from the dismissal of that last bankruptcy, what we call the second one. Then 11 USC section 362(c)(4 is invoked, which technically means that there is no stay. Now, an issue with that second, we're going to go back to the second bankruptcy real quick and discuss that process where they have to file a motion and they have to get it granted by the bankruptcy court within 30 days of that bankruptcy petition date, the date they file it. What we have to remember, because a lot of times the board wants us to go in there and object to it, okay? And sometimes we can negotiate without going to court conditions on that or stipulations. But what we have to remember is that there is case law now since this whole BAP-CIPA reform and so forth with regard to 362(c)(3, which specifies that the stay, okay, that's in effect, that the filing of that second one terminates the stay only with respect to the debtor, the person, and not property of the bankruptcy estate. This is especially true, and Clint can attest to this better than any attorney. This is especially true where the HOA is included in the Chapter 13 plan, which creates a contractual obligation to follow what they've scheduled in the plan. But there is case law that specifies that it's only with respect to the debtor that the stay terminates, not to the property.
So again, kind of summarizing all of that, if we're dealing with an owner who files bankruptcies multiple times, number one, and then number two, within a certain period of time, the association may be able to get some relief from the automatic stay. However, if there is a contract, and when I say contract, I'm referring to the Chapter 13 plan. So there's a contract between the court, trustee, debtor, and the association. If there is a contract, even though the stay has been lifted, we may not be able to proceed with foreclosure against the property because there is a contract in place. So you've really got to think about that when you want to consider whether or not to pursue a motion to lift or relief from the automatic stay. So again, getting with your counsel is very important to do when you're dealing with multiple bankruptcies being filed within a certain period of time. Okay, so we've been kind of hinting around this for the first 20 minutes or so, but what is in rem and what is in personam? So let's kind of go back to just basic real estate law. So Bob, sorry if there are any Bobs out there, I'm picking on you. Bob comes into ABC Association and he buys property within ABC. ABC Association, of course, has a declaration of covenants, conditions, and restrictions that have been filed by the developer. And if you look at that document, there's an article that talks about assessments. And if you really read that document, it says that every owner in the community grants to the association a lien against the property and agrees to be personally responsible for all the amounts due and owing. So when Bob buys in, he enters into an agreement basically that says, hey, look, I understand there is a lien against the property, and that's the foreclosure rights. And I understand that I'm going to be personally obligated to pay those monies. So lien rights is our right to foreclose. What can we foreclose on? We can only foreclose on secured amounts. So amounts that are connected to that lien. And your document will tell you what amounts are secured and what amounts are not. Now, if you're a condominium, your secured rights are also governed by state law, Chapter 82 of the Texas Property Code. I believe it's 82.113. It is more applicable to TUCA condos, so those condos whose declaration was recorded on or after January 1st of 1994. It may be applicable to pre-TUCA condos as well, but you've got to look at your documents to make sure there's not some sort of conflict. But regardless, amounts that are secured typically are your assessments, your interest, your attorney's fees, and then late fees and fines and other fees. They may be secured. It really kind of depends on your documents. If you're a condo, typically all of the above is secured. So secured means in rem. That means it is against the property. That is our right to foreclose. In personam, however, includes secured amounts and unsecured amounts. So even though the stay may lift automatically as to the in personam liability, the in rem is still protected by the automatic stay because it is part of the estate. And that's the slide we just kind of discussed. Mary and I are going to talk about in rem and in personam liability as we continue on in this presentation, but that's really what it is. In rem means liability against the property, i.e. secured amounts. In personam means liability against the person, i.e. secured and unsecured amounts. All right, Ms. Shiloh, what do we got?
So that was excellent. The thing that we're keeping in mind as far as the difference is that under certain circumstances and meeting certain conditions, okay, the automatic stay may be relaxed, modified, or possibly lifted entirely. For these possibilities, to pursue deed restriction violation enforcement under state law remedy, okay, or to pursue NREM only relief as to the property only, as Clint was saying. to the property, not to the person, just the property. So obtaining such an order is a process. It is a process. It does not guarantee quick resolve, and it may only provide a limited time frame within which the debtor, your homeowner, must perform certain actions, okay? And this depends on the wording, the purpose of the motion that brings us into court for this purpose, but the certain actions may be to actually cure violations that are on the property, or to make a certain payment by a certain time. For example, if you have an agreement with the debtor and they want like a payment plan, and their post-petition years are, say, 2021 and 2022, but 2023 is right around the corner. Of course, it's here now. You can make a stipulation sometimes that in order for the payment plan that you agree to coordinate on post-petition, that it include the timely payment of the 2023 assessment. And of course, as you all know, this is why we all get so bombarded with calls, emails, all sorts of inquiries of people throughout January and, of course, into February often as well.
Perfect. So let's talk real world, and I'll do collection first, and then we'll do deed restriction enforcement. So collection first. Huge pre-petition balance. And again, from last week, pre-petition means all amounts due and owing prior to the date and time of bankruptcy filing. So backwards. Huge pre-petition balance on the account. They haven't been making payments to the association because they haven't been making payments to the trustee for disbursement to the association. And let's assume the trustee hasn't done a motion to dismiss yet. But we've got a big pre-petition balance. We also have a big post-petition balance. So the client, the association, wants our law firm to do some action, be aggressive. So we reach out to the debtor, try to get them to catch up. No response, or debtor's counsel can't get the debtor on the phone via or via email. So y'all approve us to file what's called a motion to lift the automatic stay, or motion for relief from the automatic stay. We attach all the exhibits. We file the motion. Number one, there is a limit to how much in attorney's fees we can request. It is a cap.
Yes.
Period. End of
Yes.
sentence. Can't go over the cap. Most of the time, we're going to have to go over the cap if we have to show up to the hearing. Period. End of sentence. So the association has to understand that we're likely not going to recover those attorney's fees. Number one. Number two, after we file the motion and set a hearing, many times we are finally able to get the debtor to wake up. And the debtor's counsel and myself and Mary will all work together, and we're typically going to recommend what's called an agreed order conditioning the stay. As Mary mentioned, it's an agreed order conditioning the stay that we file, and we get the court to approve it. We may have to show up in court to argue it, and the court will ask some questions. Most of the time it gets granted. And think of it like a payment plan. It's a statutory payment plan in bankruptcy court. And if they fail under that payment plan, we've got to send them a notice of default. And if they keep failing, we can file something with the court, notifying them of the failure and indicating, basically a notice confirming the termination of the automatic stay. Then we can proceed against the property only for foreclosure remedy, if that's what we want to do. So that's collection. Everything I just went over, however, is not a guarantee. It's not, because a court is very reluctant to kick somebody out of their home when they're in an active bankruptcy. That's the collection option. The deed restriction enforcement option, you've got two ways to enforce your restrictions. And again, I'm going to do a kind of, before we get there, Mary is going to reach out to debtor's counsel, and we may send a nasty gram letter trying to get the violation fixed. All that fails, the client has two options. Option number one is to file a motion to lift the stay or relief from the stay, again, citing the reasons for it and indicating we're just seeking to enforce our deed restrictions. We're not going to foreclose on the property, but we need to go after the person to get compliance. That's option number one. And again, there may be a way to even not have to file the motion, but I don't recommend it. The case law is a little murky in that area, and you want to be safe. Better safe than sorry. Option number two is to initiate what's called an adversary proceeding, where you actually set up litigation in the bankruptcy court to try to get the deed restrictions enforced. That one, you're going to have a lot more involvement by the judge. That can be a good thing or it can be a bad thing. It can be a good thing if the violations are very, very, very egregious, because the bankruptcy court is not going to be happy. Because basically the debtor is using the bankruptcy process as a sword, and it shouldn't be designed as a sword. It should be designed as a shield, and bankruptcy judges don't like that. But if the violations are a little bit more ticky-tacky, that kind of build up and are not good for the community, then we may recommend a motion for relief from the stay. But again, none of this is a guarantee. Bankruptcy judges are going to have an inclination towards protecting the debtor. So you have to go into the process understanding that. Oh, the CARES Act, Miss Shiloh. You want to go into some details on this and how it's impacted creditors and POAs?
Absolutely. And as many of you have experienced, the whole Chapter 13 bankruptcy process, one of the things that's most frustrating about it is the length of time involved. Because although there is a maximum length of the duration and administration of a Chapter 13 plan, it's 60 months, which is 5 years. I mean, it's like an auto loan, like an extended auto loan. So to make things even more frustrating, especially for us out there that are trying to collect these assessments and keep everything going, the CARES Act, the Coronavirus Aid, Relief, and Economic Security Act of 2020, part of its provision extended to the auspices of the United States Department of Justice that oversees the bankruptcy process. And what the biggest outcome of that was by the debtor who was in a bankruptcy effective March 27th, 2020, which is like the D-Day, day zero considered of the COVID pandemic, is that debtor in that bankruptcy was afforded the ability to extend the Chapter 13 plan duration and administration from 60 months to 84 months. So yes, an additional 2 whole years were allowed to be added to a Chapter 13 plan. Again, that was effective March 20th, 2020. And it expired sometime last year. So we're now out of that window. But if you'll notice, some of these bankruptcies that have been going on, it can make you think, what happened? Did they file another one? Well, no, they got an extension by 2 years of the current one. Now, if they were dismissed anytime during that effective period after March 27th, 2020, they were allowed to file another bankruptcy and again invoke the CARES Act to extend from 60 maximum months to 84 total months. So this had kind of a domino effect, even where we saw some dismissals and it looked like maybe some of these debtors were going to try to get things back together on their own outside of the bankruptcy process. unfortunately, that hasn't happened in many cases. So yes, you are still seeing 2016, 2017, 2018 bankruptcy cases still going on today. And it's like, wow, how is that? Well, it's because they met this window of that effective period and they were able to extend it. So what it did under Section 1329 of the Bankruptcy Code is it extends the length of a Chapter 13 plan under certain circumstances, right? So what did they have to prove? Well, it was in the Southern District, I can tell you especially, it was very loosely regulated. And most of the time it was just generously granted. And, you know, I mean, who's going to come into court and say, oh, no, judge, they shouldn't have any relief under COVID? COVID didn't affect them. Yeah, so we didn't. But also, it was that there were provisions making sure, supposedly, that it's not more than 7 years from when the first plan payment was due. So while some of these we may analyze them, take a step back and say, well, hold on, this may have been within that March 27th, 2020 provision, but we're getting into, year 6, how long is this going to be? 9 years? Well, the stipulation is that it's not more than 7 years from when their first plan payment was due to the trustee. So even then, this provision of the CARES Act kind of extended beyond the petition date or the effective date under that provision. So it's when the debtor is experiencing or has experienced a material financial hardship due directly or indirectly to the coronavirus disease of 2019 or the COVID-19 pandemic. And if there is a bankruptcy plan modification that's approved after notice and hearing. So there were stipulations under this. It wasn't just a blanket, everybody gets an additional 2 years. But I understand that when you're dealing with these severely delinquent accounts, it sure feels like they just get, any excuse necessary. But there were actually stipulations. So enough about that.
Yeah, so basically the bar was very low. And what does it mean for us? Well, we could be dealing with bankruptcies that are going to be 2 years longer. So
Yep.
It is what it is, but Mary's been having to work through that on a lot of these matters, and clients just scratching their head. Hey, Mary, what the heck's going on? Why is this bankruptcy still active? Well, it's still active because of the CARES Act. More from COVID. Miss Shiloh, what are you seeing on mortgage foreclosures?
Well, I have a bit of an update to this slide. Generally, I put it in there initially to let everyone know that it is not your imagination. There are actually fewer mortgage foreclosures. While part of that is due to, COVID generally and whatever each mortgage servicer has decided to do to make nice and give people another chance, understanding that these mortgage servicers, they benefit more than anybody out of having a debtor having to file a Chapter 13. Why? It's no skin off their nose for them to go and have a claim in a Chapter 13 bankruptcy where they have to be paid 100%, okay, by the debtor in order for the debtor to keep their house. So these mortgage companies, they just sit back and they go, oh yeah, file as many times as you want as long as we keep getting those payments. And of course, a lot of times, as you all know, the HOA ends up holding the bag. But there's an additional layer to this, and it's under the CFPB, or Consumer Financial Protection Bureau. And there are some footnotes here where I give kind of a more detailed explanation, and you can look these up. And if you need any further documentation to explain to your board members, you can use that as well. So what we want you to understand is sometimes your counsel for your HOA may reach out to you and ask you to play nice, consider a waiver of certain charges or soft costs, something to work an agreement, possibly to prevent a short sale of the property where the HOA might get nothing. And worse than that, have additional legal fees, to contend with, as well as getting nothing. So that would be getting less than nothing. But it's not your imagination. There is a waive in this CFPB provision to allow for graduated, refinance, remodification of a mortgage agreement to keep people in their houses and to stave off mortgage foreclosure.
All right, so the HOA reserve, it is not as a result of a reserve study. It is not something that the association uses for repair, replacement, or modification of capital improvements. HOA reserve, this term of art is for bankruptcy today. So throw the typical definition of reserve out the window. What is it, Mary?
I was going to open the window and let it out, that other definition. So an HOA reserve inside of a Chapter 13 plan, and it only applies to Chapter 13, does not apply to a Chapter 7 or a Chapter 20, converts to a 7. It's a special piggy bank or safe deposit box that is reserved for the HOA. Now, there are other types of HOA reserve, namely for the taxes, sometimes for some additional layer of taxing authority or MUD authority or something like that. But it's where it concerns the debtor's principal residence. Okay? So we're talking about homeowners that are saving their homestead, their principal residence, by having this Chapter 13 plan. Then the reserve, the idea is that for every payment or every pullout that the trustee does from the debtor's paycheck, that a portion of that, and sometimes it's $46.13, a portion of that goes into this HOA reserve account. And then it multiplies and it multiplies. And the idea being that for the next year's post-petition assessment, as it becomes due and owing, that the trustee can cut a check to the HOA in payment of that new ongoing assessment. So the idea, and this, we worked on this for years, and finally we had a panel with the judges and got this all under wraps by December 1st of 2017, because you will not see a bankruptcy filed prior to that date that includes a reserve. It's not your imagination. And so to handle this ongoing problem of people sitting in bankruptcy for 4 and 5 years and never paying their HOA, and then getting out of bankruptcy and calling their HOA and saying, why did you send me this bill? I've been in bankruptcy. And then having to explain to the homeowner, right, but your bankruptcy didn't pay every year as the assessment became due and owing. And that's the purpose of an HOA reserve. And if you have any questions, reach out to me on it, but don't credit an HOA reserve trustee check to a pre-petition account. And then we get into trouble with that. But reach out to me if you have questions on your accounting of it.
So it's basically a way to pay post-petition assessments without having to have those build up year after year after year. Because Mary and I fielded all kinds of phone calls, emails from our client, rightly so, being frustrated because they haven't been paid year after year after year. And Clint and Mary, you told us not to send a post-petition demand letter. And our response is, well, no, We didn't say that technically. We said, don't send the letter where you're threatening foreclosure and turn over to the attorney. It needs to be a different designed letter. Anyways, the trustee bankruptcy courts all recognize this, and that's where this HOA reserve account idea kind of came into being. And it's been very beneficial for a lot of our clients across Texas.
Yep.
Okay, so dismissals moving forward. Homeowner's bankruptcy was dismissed, i.e. dissed, rejected, denied. What do we do? So number one, the law says this: it is as if the bankruptcy never occurred, never happened. So if we have a judgment, or if we're in active litigation, so if we have a judgment, we can proceed with posting the property for foreclosure. We'll send one letter and then we'll proceed with foreclosure. If we have an active lawsuit, we will notify the civil court that, hey, they're out of bankruptcy now, please get this back on the civil docket, and then we'll proceed with either a summary judgment or a default judgment, or if the owner contacts us, an agreed judgment. If there is no active litigation, so we're in a pre-litigation stage, and we're talking single family right now, we're going to recommend the client send a new 209 letter, new 209 notice letter, chapter 209. And then once that letter, and now it used to be 30 days, now it's 45. Once that 45 days elapse, then you re-refer it to our office, and then we can proceed with normal collection activity. If you're a condo, technically the condo does not have to send a new letter. So if the condo wants us to proceed without them sending a letter, they can. They just advise us of that request in writing. Now remember, 209.0051H, as in Harry, of the Texas Property Code, single family only, prohibits a board from initiating foreclosure actions or enforcement actions unless done so in an open session of a properly noticed board meeting. Now there's ways to kind of address this through a collection policy or a good deed restriction enforcement policy. But the belt and suspenders general rule of thumb is make sure you have in your notice, consider and vote on collection actions. And then at every meeting, regardless of whether you have a collection action, keep that in your agenda and then vote on it, open session. Well, how do you do that without disclosing an owner's private information? You can reference the last 5 digits of the account. You can reference a dollar figure. You can reference the fact that there was an owner whose bankruptcy was recently dismissed. I make a motion to authorize the law firm to do X, Y, and Z, including foreclosure. There's a multitude of ways to get it done the right way without disclosing owner information. So that is dismissal. Discharge, honorable discharge. Okay, this is back where Mary and I were talking kind of in rem, in personam. I'm going to talk general rule of thumb, and then Mary's going to discuss what happens when there's a lien strip. And we discussed lien strips last week, but normal discharge, no lien strip whatsoever. And we're talking about a Chapter 7 discharge. So Chapter 7 owner comes in, it's like a Band-Aid, 5 months roughly, and then they receive a discharge. Can the association do anything to collect their money? Yes, absolutely. A Chapter 7 discharge only discharges the owner's personal liability. So in personam liability only. The in rem liability is still attached to the dirt, still attached to the property. So what you do is you send, and by you, I mean our law firm, and we're going to help you design a Chapter 209 letter as well. You send a 209 letter only against the property. It cannot be against the person. And then you refer it to our office. We send a letter. It's called an in rem demand letter. And it basically says, hey, Bob, I'm picking on Bob again. Congrats. You were successful in your bankruptcy, Chapter 7, and certain Chapter 13s. You got a chapter, you got a discharge. Congrats on turning over a new leaf. But guess what? The property still owes the money, and we are going to be foreclosing on all secured amounts. If you want to avoid that, contact us to discuss options. But we're not seeking it against you. We are only seeking it against the property. Now, Mary, what happens if we're dealing with a Chapter 13 and there was a confirmed lien strip, i.e. the HOA's lien was stripped?
This is tricky. So this is the part where after confirmation, a lot of times the client will ask, do I write off this amount? And we say, no, not yet. Hold it in suspense. But after a confirmed Chapter 13 lien strip, where a Chapter 13 discharge is involved, they don't get to flip-flop over to Chapter 20 and get a Chapter 7 discharge. Where a Chapter 13 discharge was entered, then we have to write off that pre-petition balance that was owed as of the date that they filed that was subject to the lien strip provision of the confirmed plan. So the plan has to be confirmed, it has to be completed, and it has to be a Chapter 13 discharge. Then you have to write it off.
And your counsel should be giving you advice on this and telling you what to write off and what not to write off, and whether something is collectible against the person or only the property, or both. All right.
Exactly.
Let's get our roundup here. So again, violation of the automatic stay, all it takes is one letter.
Just
one
one.
phone call, one email, just one, and you violated the automatic stay. Again, it is a strict liability statute. You only have to ask a couple questions. Is there an active bankruptcy? Yes. During the bankruptcy, did you make a demand for payment, threaten foreclosure? If the answer to that question is yes. Third question is, did you get notice of the bankruptcy? It doesn't matter if it's on your desk. Doesn't matter if you didn't see it. Did they provide you with notice? If the answer is yes, then it's a violation of the stay, which entitles them to seek damages, which includes attorney's fees. And that's kind of the big dollar figure. Violating a confirmation order. Remember, the Chapter 13 plan is a contract between the association and the debtor, trustee, and court. So you've got to be aware of that, and you cannot breach that contract, because if you do, it's considered a violation of the confirmation order. Violating the discharge injunction. So discharge means an honorable discharge. They did what they needed to do. And again, you've got to rely on your counsel for them to tell you what to keep and what to write off. Because if you go after something that should have been written off, that's a violation of the discharge injunction, which can lead to another lawsuit against you. And again, what is a violation? Notice or demand letter demanding payment and or threatening legal action. And again, number one culprit that Mary and I see over and over and over again is the auto-generated statements. It happens. So make sure you've got a good flag process in place so that when an account is flagged, you're not sending demands. All right. Well, let's we've made it with about 5 minutes left for questions, Miss Shiloh. Let's see what we've got here. So here's one question. Can you address how the statute of limitations impacts pre-petition balances more than 4 years old? So statute of limitations for collections in the state of Texas is 4 years, right? The big four. So Bob, the debtor, files bankruptcy in year one. And let's say it's a 5-year bankruptcy. They get a confirmation order. They go through almost to the end, and then they get dismissed, right? Kicked out, dissed. Can we still collect those monies that we're due and owing in year one? Because they've been in it for almost 5 years. The 4-year statute of limitations has come and gone. The law says this, and it's not federal law, it's actually state law. State law in the state of Texas says this: the minute a bankruptcy gets filed, that statute of limitations clock freezes, does not move anywhere. So even though we're dealing with 9 years past due and owing, if we go back 4 and then add another 5, we can still collect those amounts due and owing. Now, the minute there is a dismissal, that clock starts ticking again. The clock may also start ticking again if there's a surrender of the property as well, or there's an absence of the automatic stay. You've got to be aware of all of those things because that could trigger the clock restarting. But the general rule of thumb is clock freezes when bankruptcy gets filed. Oh, the video's choppy. I'm sorry. Seems like it's going smooth on our end. And then finally, will this presentation be sent to us? As Mary mentioned earlier, you're looking about a 1 to 2 week turnaround time, and then it'll get posted to our website. There's a little link you can click on. Additionally, if you type in YouTube and type in RMWBH, there's a whole laundry list of the same videos that are posted through YouTube. Mary, anything else you'd like to say before we wrap up?
Well, I did miss one important update. Sorry. When I was on the part about the CFPB and how it's not your imagination, there really are fewer mortgage foreclosures. I forgot to mention, and I really wanted to, that understand that even where your homeowner has become a debtor in a Chapter 13 bankruptcy, they are still afforded, and this again with the CFPB provisions, a homeowner assistance program. And there's one company called the Yardy Systems. There's another that's federal, that's like through Fannie Mae, various different, but it's always called homeowner assistance programs. If you're contacted by one of these people and it's an account you have with your counsel that is a bankruptcy, please reach out to your counsel as far as dealing with it and keeping everything intact and how they want it presented. They have specific requirements similar to filing a proof of claim. Even if you have a proof of claim on file with the bankruptcy court, this is something completely different, okay? So we may have to submit a separate invoice, and it may include pre-petition that's covered in the proof of claim. It may include only post-petition, but it's a homeowner assistance program. And again, reach out if you have questions on it. But it is working and HOAs are getting paid.
Thank you, Ms. Shiloh. And hey, thank you all for joining us today. Again, the 201's a little bit more in depth, but through the lack of questions, hopefully that means we did a good job describing some of those more complex issues. I hope y'all enjoy the rest of your day and your Valentine's Day, and y'all just enjoy your week. Bye, everybody.